And for labor rights issue, in the TPP negotiations, the U.S. wants TPP members to implement and enforce the 1998 Declaration on Fundamental Principles and Rights at Work of the International Labour Organization, ILO. The ILO Declaration covers 5 basic principles: freedom of association, right to collective bargaining, a ban on forced or compulsory labor, the effective abolition of child labor, and a ban on discrimination in employment or occupation. So the U.S. also demands that the labor obligations be subject to the dispute settlement mechanism. So it applies the same analysis as mentioned in the environmental issues. Taiwan is not a member of the ILO. Joining TPP will expand Taiwan's legal status under the international labor law. And the intellectual property right, the IP negotiations are very controversial at the bilateral and multilateral level, such in the World Intellectual Property Organization, WIPO, or World Trade Organization. The U.S. Stop Online Piracy Act, SOPA, which is not passed by the U.S. Congress, and the Plurilateral Agreement Anti-Counterfeiting Trade Agreement, ACTA, which is not ratified by most of the negotiating parties, have both failed. It testified a new hostility in the public policy environment for domestic and international IP lawmaking. So the other factor is that the TPP IP negotiations will increase complexity and fragmentation of the international IP legal making procedure. Signing up to new set of IP standards in the TPP could complicate the multilateral IP negotiations in the WIPO. So then it is necessary to coordinate between these international law-making procedures. So then TPP will help Taiwan to open the window for participating in these international legislation activities and strengthen its legal status in the international arena. So then for state-state dispute settlement. So most modern preferential trade agreements contain state-state dispute settlement mechanisms, and it will change our understanding for the modern sovereignty as well. And the TPP will be no exception. So the consequence is that there are multiple overlapping trade treaties between various subsets of TPP parties, and each contains their own dispute settlement systems. For example, between Singapore and New Zealand, TPP will be their 5th trade treaty. So then, between New Zealand and Singapore, they have to decide between, when they have trade dispute, they have to choose one from these 5 trade treaties to solve their dispute. So it raises, of course, a question in relation to the conflicts of norms and conflicts of jurisdiction between the different systems. So it also needs to address the rules of interpretation, so which were used by TPP tribunal. And these competing international trade judicial systems inevitably enhance and enforce the substantial international law. And it also relativizes the concept of sovereignty by making the state accountable and reliable. The TPP will contribute to this constitutionalization of international trade law by designing a new mechanism to solve these questions. So the TPP will bring members fuller to be integrated into the international legal system, and it will bring positive implications for Taiwan's sovereignty as well. Then come to the investor-state dispute settlement mechanism. It demonstrates the evolution of the concept of sovereignty as well. This poses unique problems for countries that uphold the principle of absolute immunity of sovereign states. So the most important example is China. Till now, Chinese court will hold that China, as a sovereign state, is immune from any lawsuit by inbound investor. And nor will Chinese courts enforce arbitral awards made by commercial arbitration institutions against China. So due to Taiwanese huge outbound investment in the region, it will be recommendable for Taiwan to support an effective investor-state dispute settlement mechanism and to hold the sovereignty in check under the international law is also in Taiwan's national interest. So the last point for the TPP is about the regulatory coherence. So the inclusion of the chapter on regulatory coherence in the TPP represents a major development towards the effort to harmonize the domestic legislature between members. The goals of the regulatory coherence are to eliminate unnecessary regulatory barriers and to make regulatory systems more compatible and transparent. And it will include the mechanism to achieve greater domestic coordination of regulations, to increase transparency and stakeholder engagement, and most importantly, in trade terms, is to improve small and medium-sized enterprises' competitiveness and their ability to engage in international trade through a coherent regulation will ease their business burden. The draft Article 10.1 of the TPP states, the party affirms the importance of each party's sovereign right to identify its regulatory priority and regional regulatory cooperation taking into account the parties' international obligations. And according to this draft text, the TPP members' sovereign right and its international obligations are explicitly emphasized. So it will bring positive implication for Taiwan if Taiwan joins the TPP as well. So based on the discussion under the international law dimension, so the best strategy for Taiwan to counter China's attempt to isolate Taiwan from international participation actually is the 3 steps. First, we need to fulfill our international obligations with best efforts. And Taiwan needs to integrate itself into the international legal system. And third, to stay on the right side of the history. And what is the right side of history? Actually, it's identical with democracy, development, and the war.
I like the beginning of this slide.
Yeah.
I like the whole slide.
And I'm not suggesting to change the name of the center, the CDDRL, into the center on the right side of history.
They're the same thing.
So, as Professor Francis Fukuyama observes, rule of law is important in China not only for commercial purposes, but for survival of the leadership. So he says, quote, rulers try to evade the law if they can, but at a certain point, they realize that it's safer for them if they actually have rules rather than just arbitrary struggle for powers, end of quote. And Professor Fukuyama also notices part of the process of entering the WTO for China was creating legal institutions that would allow Chinese firms to interact with international firms and so forth. So actually, the accession to the WTO helped China to integrate into the international legal system, and it helped its domestic firms to understand the international commercial regulations as well. So actually, TPP will eventually bring the similar effects for China, for China's reform. So to include Taiwan in the TPP will create a strong incentive for China to consider its position towards the TPP. So it could be a win-win situation. So now let's turn to the beginning of our the presentation. So let's now examine the argument made by Professor Gu. So he mentioned that, quote, "But both the US and Japan have made clear that China is a single legal entity that includes Taiwan, and that the PRC is the sole government in charge of this entity," end of quote. So it's his reason saying if China uses forces to attack Taiwan, it's legal. But it's just not the truth. It's clear that China and Taiwan are different legal entities under international law, as we have just discussed. And in a hedge fund, they would probably say it's a misfortune in the investment to provide Professor Gu the Taiwan scholarship. So the Congressional Research Service, CRS, document on U.S. policy towards Taiwan by expert Shirley Kahn and Wayne Morrison defines U.S. policy briefly as, quote, "The United States has its own One China policy versus the PRC's One China principle and position on Taiwan's status, not recognizing the PRC's claim over Taiwan nor Taiwan as a sovereign state. U.S. policy has considered Taiwan's status as unsettled," end of quote. So actually, Taiwan has participated in the international regime under different status. As we have discussed, it is as a custom territory to access the WTO, and it is as an economy to join the APEC, and as a fishing entity to participate in the International Fishery Reservation Organization under them. So, and also a lot of people have suggested that Taiwan can participate in the multilateral environmental agreement, such as the Kyoto Protocol, as an emission entity. But it sounds more like a car than a legal entity. So now let's come to the conclusion. Actually, Taiwan should be an equal member in the international system, even under different names and legal status. Yeah. So conclude my presentation.
I don't think you're going to find anyone disagreeing with your conclusion here. But thank you very much, Joseph, for this very informative and stimulating presentation.